BEONTV UK, for the community, by the community. www.beontvuk.com.
আসসালামু আলাইকুম, আমি শেবুল চৌধুরী। BEONTV UKতে আইয়ার উমরাবতী নামক একটি অনুষ্ঠান লইয়া, যে অনুষ্ঠানও আমরা কথা কইমু গাছ গাছালি লইয়া, বাগান লইয়া, ফল ফুল লইয়া, এবং অতিথি হিসাবে থাকবা বিভিন্ন বাগানীরা। দেখব আপনার লগে BEONTV UK পর্দায়।
আসসালামু আলাইকুম, আমি রাশিয়া খাতুন। BEONTV UKতে লইয়া আইরাম আমার নতুন প্রোগ্রাম অনুক্তের মুক্তি। আমার এই প্রোগ্রামে থাকবো বিজনে থাকা অনেক মানুষ, তাদের যে কথা কোনোদিন খেল লগে শেয়ার করছেন না, এই কথাগুলা আমার প্রোগ্রামে আপনারা লগে শেয়ার করবা। চোখ রাখুন BEONTV UKর পর্দায়।
BEONTV UK, for the community, by the community.
Welcome to the fourth episode of Legal Solutions with sarafkhan. UK এবং অন্যান্য দেশ থেকে যারা এই অনুষ্ঠানটি দেখছেন, আশা করি সবাই ভালো আছেন এবং সুস্থ আছেন। আমি sarafkhan BEONTV UK স্টুডিও থেকে কথা বলছি, এবং আজকে আমাদের কথা বলার বিষয় ইনহেরিটেন্স অ্যান্ড ইমপ্লিকেশন অফ ডিভোর্স অন প্রপার্টি ডিভিশন। যারা ডিভোর্সের মধ্যে দিয়ে যাচ্ছেন, তারা কিভাবে আপনার এক্স-স্পাউসের সাথে প্রপার্টি ডিভাইড করবেন, এবং আপনি যদি পার্সোনালি উত্তরাধিকার হয়ে থাকেন কোনো সম্পত্তি বা টাকা পয়সা, সেটা আপনার এক্স-স্পাউসের সাথে ডিভাইড করতে হবে কিনা বা কিভাবে করবেন, এই বিষয়ে আমরা বিস্তারিত আলাপ করতে আমাদের মাঝে উপস্থিত আছেন জনাব ব্যারিস্টার শাম উদ্দিন। He has been in the legal field for 25 years, who is specialized in family, civil and criminal law. He is currently working both in London and Birmingham. And most importantly, he has direct access, which means that he can accept instructions from you. অনুষ্ঠান চলাকালীন যদি আমাদের স্পেশাল গেস্টের কাছে আপনার কোনো কোয়েশ্চেন থেকে থাকে, তাহলে স্ক্রিনে যে নাম্বারটি আছে সেই নাম্বারটিতে কল করবেন। আসসালামু আলাইকুম।
Walaikum salam.
Thank you so much for coming to our studio. We are delighted to have you here.
Oh, it's my pleasure. Thank you very much for inviting me. It's my pleasure to be here today.
So, moving on to the first question. What is inheritance?
Well, inheritance is effectively what people inherit on the death of a particular person. It could be their parents, it could be their wives, it could be their children. So it is what you would inherit. Now, in order to inherit the property that the deceased or the person who has died owned, it can be inherited in two ways. Either the person has made a will, and in that will the person has said where and to whom their property, their money, their chattels should go to. Or alternatively, if they haven't made a will, then the law decides who has it. Now, there is a popular misconception, especially in the Asian community, there's a misconception, which is that people think that if you don't make a will, therefore, on your death, the government takes everything. That is not true. And I hope today I could try and break that down and assure people that that does not happen. It does happen, but it's very, very rare, and I'll come to the rare circumstances. But if I may just deal with the issue regarding wills. So if you make a will, you will appoint somebody called an executor to gather in your assets, your property, your money, whatever that is, and then distribute it in accordance with your wish. Now, for example, you may wish that a particular charity to have something from you, or a friend to have your watch or something. So your will dictate where and to whom it goes to. If, however, you have not made a will, you die, and the issue or the subject or the particular name given to it is called intestacy or intestate. So you've died without a will. If that happens, the law comes in. And what the law says is this: if you have died without a will, then the value of your estate is taken into account. So if you were married or have a civil partner prior to your death, then the first £270,000 of the value of your estate goes to your wife or your husband, whoever you've left behind, as long as you're not divorced or separated from them. But it has to be divorced. If you're separated, it doesn't count. They still count as a spouse. If, for example, you have left a estate of, say, £500,000, so the first £270,000 will go to your spouse, and the balance will be divided into two, and 50% of that will go to your children, and the other 50% will go again to your wife or your husband or your partner, your legal partner. So, and then if, for example, when you die, you haven't left a wife or a husband or any children, then what happens is, if you have left parents, it'll go to your parents. If, however, your parents have died before you, then if you have left brothers and sisters, it will go to them. If you have no brothers and sisters and they've got children, then it'll go to them. So there's a long list of people, and once there is no blood relations or stepbrothers or uncles or aunts, I mean, there is a list. If there is nobody, then it goes to the government. So you hopefully will appreciate, in order to go to the government, it doesn't go to the government, it goes to the Crown, Her Majesty, it is the government. But in any event, there is a long, long list before we get to the government. So don't worry if you haven't made a will. Obviously, my advice is to make a will. It's very cheap to make a will, and you avoid all the issues. So that's where people get their wires crossed when they think it goes to the government. So that's that.
But is an Islamic will valid under English law?
Well, an Islamic will can be valid under English law, because the position is this: a person has the right to make a decision as to how their assets are distributed upon their death. Now, Islamic Sharia law has a particular way of distributing assets. However, if, for example, you have a spouse, and rather than give them say 50%, you give them 1/3 or whatever I don't know the particular way it's distributed under Sharia law. But if, for example, the Sharia provisions conflict with what the spouse may be entitled to under English law, then the English law will take precedence. So, for example, if you have distributed your assets under the Islamic Sharia law, but that has then left the spouse either destitute or in financial hardship, then the English law will say, well, no, that cannot be right. We will not allow that particular provision to take effect, but this particular to take effect. Or, for example, there is the provision dependency. A particular dependent who has not been made a beneficiary under a will, then again, they may be able to make an application. There are time limits under which you've got to make the application. So the answer to your question is this: yes, an Islamic will, a Sharia compliant will, on first sight does have validity. However, if it in any way conflicts with the fairness or the distribution of assets that should rightly go to a dependent, then obviously that could be overridden.
So another most common questions asked by most people is that how inheritance and divorce are related.
Well, inheritance and divorce can be related in this way. If, for example, you have made a will, and you then are divorced and you have a decree absolute, then that will, in essence, when it comes to that spouse, is not valid in that regard. Or alternatively, if you've separated from your spouse but you haven't divorced, got a decree absolute, and you die, then if you haven't made provision for them, or alternatively, if you've died intestate, like I said earlier on, they would get a portion of your estate. So it is related in that way. So the way to deal with that is, obviously, if you've gone through a divorce, then you should update your will immediately, because you've got to be very careful that either your ex-wife or ex-husband could get something that they're not entitled to because you haven't updated your will.
Does it mean that it is an automatic process, like automatically it goes to the ex-spouse?
No, it doesn't automatically go to the ex-spouse. If you haven't made a will, you will die intestate. If you are still married to them legally, but you are separated, then they are classed as your spouse. And so, yes, automatically, they will be entitled to the first £270,000 of your asset.
What happens to inheritance received after marriage? And does it make any difference if it has been received before marriage?
Okay, so I think the question you're asking is this. If you are married to a particular person and after your marriage you receive inheritance from your parents or father or mother who's died, is your husband or your wife entitled to that inheritance? Is that the question?
Yes.
Well, the answer isn't straightforward. The answer is this. Under English law, when people get married, you effectively are in a partnership. So the primary position is you bring to the table what you had previously, the other party brings to the table what they had previously, and during the course of the marriage, if you either are successful in your business, it's in the pot, and the same will apply to inheritance if you've received inheritance, because you're a couple. And as a couple, you're a partnership, and your partnership, it's akin to a business partnership in essence. If you are in a partnership and your business makes profit, then both of you are able to take the fruits of that partnership. So in that regard, yes. So if, for example, somebody has inherited within about 3 years of their marriage property from a deceased parent, and about 6 years later they get divorced, then that particular inheritance can count as matrimonial assets, and therefore the husband or the wife may be entitled to it on divorce as part of financial relief.
But how is it different if the person receives the inheritance after divorce? Can the ex-spouse come and claim that inherent property?
After divorce?
After divorce.
Well, see, this is another problem that some people don't cater for. After divorce, if you get an order from the court, which is a financial relief order, either by way of consent or a financial order, which then separates your finances, and it's called a complete financial determination made about your finances. And if after that you inherit property or items after your financial divorce, or your financial aspect of your divorce has been finalized, then no. However, if, for example, during your divorce proceedings, you don't make full and frank disclosure, and you, for example, have inherited some property or land, but what you've done is you've kept it a secret from your spouse during the divorce, and then a financial determination has been made by the court, but then later on it transpires that you didn't make full and frank disclosure, then that person could go back to court and say, look, she or he has these assets which she didn't disclose. I want the financial relief application to be reopened for a determination to be made because I think I'm entitled to it. So that's why you've got to be very careful, especially when you're going through divorce, to make full and frank disclosure about everything.
There is a commonly asked question. It says that spouse can claim half of the inheritance. Is that right?
You mean half of the inheritance they've got? Well, the situation is this. If you're married to a particular person and during the course of the marriage you inherit from your mother or father property, well, ideally what you would do is you would bring it into the pot. So in that regard, yes, it's a joint matrimonial asset in that regard, because you're not going to go to your husband and say, well, look, well, you know, I've inherited my mum's £500,000 from my mum. I'm not going to use it towards this. I'm going to use it for my own purposes. You can. There's nothing stopping you. However, on divorce, the court could take that into account as property belonging to the matrimonial pot.
Is an Islamic kaminama valid under English law?
Well, no, and yes. From this point of view, and this is the problem when you ask a lawyer a question, sometimes you don't get a direct answer, and there are reasons as to why. A kaminama is effectively an agreement that upon divorce, a person will get something, dowry or whatever it is. However, that has to be looked at in the context whether it's fair. So, for example, if it says on divorce, Mrs. X will receive £10,000 on divorce, but that £10,000 that she receives may be unfair amount. So in that regard, the court will say, no, she shouldn't have £10,000, she should have more than £10,000.
Sorry, we'll receive a call from one of our audiences. Assalamu alaikum.
ওয়ালাইকুম আসসালাম। জি, আসসালামু আলাইকুম।
জি, কোথা থেকে বলছেন এবং আপনার প্রশ্নটি করুন। প্লিজ লাউড স্পিকার থাকলে লাউড স্পিকারটা অফ করে এবং টিভির সাউন্ডটি কমিয়ে কোশ্চেনটা করুন প্লিজ।
ওকে, আমি বার্মিংহাম থেকে বলছি। আমি মিস্টার শাম উদ্দিন সাহেবের সাথে একটু কথা বলবো।
জি, বলুন
প্লিজ। জি, হ্যালো, আসসালামু আলাইকুম শাম ভাই।
ওয়ালাইকুম আসসালাম।
ভালো লাগে ভাই আপনার অনুষ্ঠানটা দেখি, আর আমি খুব মনোযোগ দিয়ে দেখি, আর বুঝছই নি। তারপরে দেখি আমার কিছু জানবার আছে, আমি জানতাম স্যার আপনার হচ্ছে। তো আপনি যদি আমারে 2-3টা কোশ্চেন হরমু, আপনি যদি আমারে কোন বিস্তারিত সুন্দর হরিয়া তাইলে আমি খুশি হইমু বা আমি উপকৃত হইমু বহুত।
ওকে, আপনার হক্কা।
পয়লা কথা হইলো যে ধরো আমরা তো বাসা থাকি, একলা সময় থাকি, বা যে কোনো একটা যদি গড় কোনো মানুষ মারা যায়, এই মুহূর্তে আমরা করণীয়টা কিটা?
কোন ক্ষেত্রে?
এরপর আমি আরেকটা কোশ্চেন করবো, আপনি কিটা একলগে বাদে উত্তর দিবানি দুইটা।
আচ্ছা, ওকে, বাট আমার পয়লা প্রশ্ন আমি বুঝছি না আপনার, বিকজ কেউ যদি মারা যায় না কোন ক্ষেত্রে?
জি জি, গড় দরকার একজন মানুষ মারা যায়, তাহলে এই ফার্স্ট মুহূর্তে আমরা করণীয়টা কিটা থাকবো, কিটা করতে হইব?
ওকে, কোন ক্ষেত্রে আপনার?
জি,
কোন হিসাবে? ম্যাট্রিমোনিয়াল হিসাবে না উইল হিসাবে না কোন হিসাবে?
বুঝছি না।
আপনি কোন হিসাবে আপনি প্রশ্ন করেন আমারে যে মারা গেলে কিতা করতা? মারা গেলে তো অবভিয়াসলি আপনি অ্যাম্বুলেন্স ডাক।
দরকার তোমার হাজবেন্ড মারা গেলা বা বসময় বাপ মা থাকুন, তারা কেউ মারা গেলা গরুর মাঝে।
জি, আপনি কোন ক্ষেত্রে জানতে চাচ্ছেন?
আমি জানতে চাচ্ছি যে আইনগতভাবে আমরা সেটা করণীয় কি, মানে কি করতে হবে একদম প্রথমেই?
ওয়েল, কেউ যদি মারা যায় আপনি প্রথমে অবভিয়াসলি আপনি অ্যাম্বুলেন্স কল করতে। আই সরি টু বি বেসিক, আমি জানতাম না এটা আপনার লিগ্যাল প্রশ্ন নি না আপনার সামাজিক প্রশ্ন আপনার করা। সরি,
মানে এখানে কি কোনো লিগ্যাল ব্যাপার আছে কিনা, কোনো লিগ্যাল ইনভলভমেন্ট আছে কিনা?
হ্যাঁ হ্যাঁ হ্যাঁ, এই সব জানতে যাচ্ছি।
যদি কেউ মারা যায় অবভিয়াসলি ফ্রম এ লিগ্যাল পয়েন্ট অফ ভিউ, আপনি যদি উইল হিসাবে জানতে চান, ইনহেরিটেন্স হিসাবে কোনটা জানতে চান, আমি আপনার প্রশ্ন বুঝছি না। আই এম সো সরি।
এটা কি মানে আপনি বলতে চাচ্ছেন যে ওনার মৃত্যুটা কেন হলো বা কিভাবে হলো, এটা কোনো লিগ্যাল প্রসিডিংস আছে কিনা এরকম কিছু, নাকি হচ্ছে কি উনি সম্পত্তি কার কাছে রেখে গেছেন?
না 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 না, সম্পত্তি না, মানে লিগ্যাল ভাবে আর কি। ধরেন আমরা তখন কি পুলিশকে কল করব, না অ্যাম্বুলেন্স কল করব, না রিলেটিভদেরকে ডাকবো, এরকম আর কি।
আচ্ছা, আপনি বলতে চাচ্ছেন যে হঠাৎ করে অস্বাভাবিক মৃত্যু যদি হয়ে থাকে এবং সেই ক্ষেত্রে অস্বাভাবিক মৃত্যু যদি হয়ে থাকে, তাহলে সেই ক্ষেত্রে পুলিশ রিলেটেড এবং ল রিলেটেড কোনো কমপ্লিকেশনস আছে কিনা?
জি জি জি।
ওয়েল, নো, অফ কোর্স আপনি যদি কেউ মারা যায় আপনার ঘরে, আপনি ইমিডিয়েটলি পুলিশ অ্যাম্বুলেন্স ফোন করতে অবভিয়াসলি, অ্যান্ড দেন অ্যাম্বুলেন্স আওয়ার পরে তারা যদি মনে করে এখানে কোনো সাসপিশিয়াস কোনটা আছে, দেন তারা অবভিয়াসলি পুলিশ ফোন করবো। অথবা যদি ফর এক্সাম্পল আপনি ঘরে আইয়া পাইলা যে একজনের মারা দেখা যার যে তাই মারা গেছেন কোনো জায়গার অ্যাটাক অথবা কোনো জায়গার ডাকাতি হিসাবে, ধরো কোর্স আপনি পুলিশ ফোন করতা, অ্যাম্বুলেন্স ফোন করতা। আই থিংক দ্যাটস বেসিক।
আচ্ছা আচ্ছা।
জি, আপনার পরবর্তী কোশ্চেনটি করুন। আপনি বলেছেন
আরেকটা কোশ্চেন আছে আমার, আমি শামবাইয়ের সাথে একটা সিলেটি ভাষায় কথা বলতে
জি
যাচ্ছি।
বলেন, বলেন।
হ্যাঁ, যে আরেকটা প্রশ্ন হইলো আমার, যে আমার পরিচিত একজন আছেন রিলেটিভ, তো তারা হাজবেন্ড ওয়াইফের মধ্যে আপনার ডিভোর্স প্রসেসিং চলে, ডিভোর্স বুঝছেন নি বহুদিনটা কিয়া। এখন তারা ডিসিশন লই তো স্যার যে না তারা ডিভোর্স দিত নাই, তো একটা খরা কিতা আর ইদেশ আপনার একজন ওয়াইফ থাকতে হাজবেন্ডে কিতা আবার কোনো বিয়া করতে পারবানি একজন ওয়াইফ থাকা অবস্থায়, কারণ আমরা ইসলামিক শরীয়ত মতে তো আছে যে একজন পুরুষের 4টা বিয়া করতে পারেন, কিন্তু এই দেশও থাকে, এই দেশ লয় কিতা মানে আবার সেকেন্ড ম্যারেজ করতে পারেনি, মানে প্রথম ওয়াইফ থাকা অবস্থায়।
আপনি প্রথম ওয়াইফ থাকা অবস্থায় আপনি ইসলামিক ম্যারেজ করতে পারেন, কিন্তু আপনি রেজিস্টার করতে পারতেন না। যদি আপনি রেজিস্টার করার যান দেন ইটস এ ক্রিমিনাল অফেন্স। এই দেশে আপনি লিগালি রেজিস্টার করতে পারবা একটা ম্যারেজ, কিন্তু আপনি ইসলামিক ম্যারেজ করতে পারবা 3টা। ইটস আপ টু ইউ, দেয়ার ইজ নো প্রবলেম। আপনি ইসলামিক হিসাবে যতটি সাইন আপনি করতে পারবা, বাট ইংলিশ ল হিসাবে
করলে এই দেশে দরকার যদি ইসলামিক বিয়া করেন এটা কি তা পরে কোনো মানে প্রবলেম হইব নি তারা?
No, there's no কোনো প্রবলেম নাই, because it's not recognized in law. So for example, আপনি যদি ইংলিশ সরি আপনার যদি ওয়াইফ থাকেন এই দেশে আইদার রেজিস্টার্ড ম্যারেজ অথবা আপনি বাংলাদেশ থেকে আপনার বিয়া করে দেশে আনছেন, she is recognized as a legal English wife, because অনেক মানুষ মনে করে যে বাংলাদেশ থেকে বিয়া করে আনলে ওদের রেজিস্টার করে। নো, দ্য মোমেন্ট ইউ অ্যাপ্লাই ফর ইউর ওয়াইফ টু কাম টু দিস কান্ট্রি, এই দেশে অথবা হাজব্যান্ড এই দেশে আপনার আওয়া করে, দেন দে আর রেকগনাইজ আ লিগাল হাজব্যান্ড স্পাউস। বাট আপনি যদি ইসলামিক ম্যারেজ করেন, দ্য ল ডাজন্ট প্রহিবিট ইট বাট ডাজ নট রেকগনাইজ ইট। আইনে যারা জ করে না, আপনার গুরুত্ব দেয় না।
আপনার কি আর কোনো প্রশ্ন আছে?
না ঠিক আছে, থ্যাংক ইউ শামবাই। আমার একটা জানারই কথা আছে, প্রয়োজন আছে। ওকে, থ্যাংক ইউ ভেরি মাচ। আসসালামু আলাইকুম।
ওয়ালাইকুম আসসালাম।
Okay.
Okay.
So, sorry. My next question was how to protect this inheritance for example, children's inheritance from divorce. Like if someone wants the inheritance to dedicate to the children, not to their spouse, how to protect this?
Well, in order to protect that, the one where you can protect it, it would be, for example, with the consent of your spouse at that time, is to put those assets in trust for the children. If both of you consent to that, both of you agree to that, and you put it for the trust of the children, it's unlikely that the court will disturb that. Because when the court looks at distribution of assets, it looks at the fairness of the spouse. What is it fair for the spouse and for the children? The court doesn't ignore, under Section 25 of the Matrimonial Causes Act 1973, the court not only looks at the spouse's needs, it also looks at the children's need, and also what's fair and the kind of lifestyle that the parties enjoyed during the marriage. The court tries to do justice as far as it possibly can, and that's why when we were talking about cabin and Islamic cabin, the court will override that if it's not fair. If it's fair, the court won't disturb it.
So as you were saying that this can be made in agreement with the spouse, so having said that, many people ask what's prenuptial agreement. Can you describe this for us?
Okay, well, that's a very good point, actually, and I think it brings us to that particular point in this regard. A prenuptial agreement in the United States and some other jurisdiction, a prenuptial agreement is valid. In the UK, a prenuptial agreement wasn't recognized. However, recently it has been recognized, but still not recognized fully, because a court could override it, because the factor that the court has to take is Section 25 of the Matrimonial Causes Act could override a prenuptial agreement if it's not fair. The primary position of the court would be to look at a prenuptial agreement and to give it validity. However, if it appears to be unfair, or it wasn't entered into with full disclosure made between the parties, and there are a host of other conditions or recommendations or views that the Supreme Court has given, and if all of those factors are not present in a prenuptial agreement when it was entered into, then the court doesn't have to recognize it. But unlike the USA, the courts in the United Kingdom have the right to override a prenuptial agreement. So, yeah.
Sorry, we have to receive a call. আসসালামু আলাইকুম, যে কোথা থেকে বলছেন এবং কোশ্চেনটি বলুন।
আসসালামু আলাইকুম, আমি বার্মিংহাম থেকে হইলাম। আমি জানতাম চাইলাম আমার ফ্রেন্ড একটার উপরে নাইফ ক্রাইম হে মার্ডার হচ্ছে, আর এখন তার কতদিন সামনে গেছে জানতাম যে কতদিন জেল হইতে পারে।
Okay, well, the topic we're covering today, আমরা যে topic cover করলাম, it's not, but I could answer that question, কোনো অসুবিধা নাই। এখন মানুষ যদি মার্ডার করে, then the sentence is life.
Life imprisonment.
Life imprisonment, yes.
Okay.
Okay.
Okay, thank you for.
Thank you.
Thank you so much.
So,
So going back to the prenuptial
Yeah,
agreement,
prenuptial.
so there are a number of criteria that the court has put in place. If those criteria, for example, as I said, if it's unfair, and so for example, when you've entered into a prenuptial agreement, you didn't give your spouse full disclosure as to what assets you've got. So for example, you could have assets in Bangladesh, India, or Pakistan, or Dubai, but you just said, oh, I've just got a semi-detached house in Surbiton in Surrey or whatever it is. I have nothing else. But after the divorce or during the divorce, you find out that he's got assets in Dubai or New York or whatever it is. The other spouse could say, well, look, when I entered into that agreement with you on the prenuptial agreement, you never made full and frank disclosure. Had you made that, I may not have entered into this particular agreement.
okay. So that's very important to make disclosure during making that agreement. And what do you recommend that can this agreement be made at any point during the marriage?
Well, no. You see, the thing is, a prenuptial agreement is the name, which is prenuptial agreement, which is prior to your marriage. However, you can have postnuptial agreement as well. They are valid as well. But again, the same criteria apply. But again, when you enter into postnuptial agreement, a court doesn't have to recognize it or recognize every single clause, because it looks at section 25 of the matrimonial code, because the whole object is fairness for the spouse or spouses and also the children of the marriage as well.
Right. So at which point of the divorce process decision is taken on property division?
Well, you mean with the court or for the parties?
As you said that the financial consent order,
Yeah.
when it has to be made after decree nisi or the
Well,
absolute-
you could have negotiations going hand in hand, but normally, I mean, in the olden days, what lawyers used to say is, I'm not going to apply for the decree absolute until we've got financial settlement. That's not correct, because you could have financial settlement after decree absolute. However, there is a strong condition. If a particular person gets married after the decree absolute, but before the financial order is made, then they cannot make an application for property adjustment. In that regard, so they need to really finish all their financial and get an order from the court, whether it's an order from the court after a trial or a dispute hearing or a consent order. You get an order prior to you getting married. So my advice is, don't enter into your second marriage until you've sorted out because you may then be barred from certain remedies, from not all, but most remedies you would be barred from applying for after decree absolute if you get married.
So is there any time limitation that the ex-spouse can make application for financial consent order after the decree absolute? Like, is there any time limit that it has to be made within this time limit scale?
There isn't a specific time limit. Like I said, you should make it before you get your second marriage.
Yeah.
But the problem is this. If, for example, you've had your decree absolute and you've not had a financial settlement, and you then go and win the lottery, then your ex-spouse will be entitled to claim your lottery winnings unless you've got a financial settlement from the court.
So that's very important.
Yeah, so
Very
if you or you inherit from your parents or whoever, or you then start a business with your new partner. Say you're not married, just have an Islamic marriage, but your ex-spouse will be entitled to a share in the profit of that if you haven't got consent order or a financial settlement. It's called clean break.
Clean break.
Yeah.
Okay. What are the factors that are considered by the UK court when dividing asset amongst the spouses?
Right. So what they look at fairness. They look at the needs, your need. So, for example, if your lifestyle was that you lived in a detached 4-bedroom house, and the court tries, not always can, try to give you the same kind of lifestyle that you enjoyed during the marriage. It's not always possible, but he also looks at the child. So, for example, if you've got children and the children live with a particular parent most of the time, say 70% of the time, 60% of the time, then that spouse is likely to get more. If, however, there's an equal division of children staying with both parents, 50-50, then the presumption is 50-50. But again, those kind of things that the court takes into account, they take into account the needs of any children of the family, and also the needs of a particular spouse. The earning capacity of a particular spouse will be taken into account, and also, like I say, whether that particular person can get a mortgage or not get a mortgage, if they were going to upgrade or downgrade.
Okay, so basically we received a few questions from our audiences through email, because we have been promoting this episode beforehand, so they sent us a few questions on email, and one of them is, if a person owns a house outright and then gets divorced, is the ex-spouse entitled to claim the house even if she doesn't pay for it?
Yes. And again, it depends how long the marriage has been for. But like I say to you, once you enter into a marriage, you intermingle your property. So, for example, in your particular situation, the question is this: a particular person has inherited a property, or it could be even that they own the property prior to coming to the marriage. The husband or the wife may be entitled to that share of that property as well, because they may have, during the course of the marriage, on the strength of that particular property, not bought another property and instead used to renovate this particular property. So there are so many factors that the court will take into account. So the answer to your question is yes, depending on the circumstances.
Another question asked by a person, and he doesn't want to mention his name, but he says that if a person owns property before marriage, what happens to that property after the divorce?
Again, like I said, I think I've just dealt with it earlier on. Depending on the duration of the marriage, what sacrifices that the other spouse has made during the course of the marriage, then yes, that property can come into the matrimonial pot. So effectively, once you get married, you're putting everything into a joint pot.
How the finance is going to get split if one of them leaves the family home, but his kids and ex-spouse are still living there?
So I think I've dealt with that, I touched upon that earlier on. So if the husband or the wife has care of the children, and the other person has just gone with somebody else or just left the marriage and doesn't want to know the children, but the spouse that has the children paid the mortgage, maintenance of the house. Again, those are matters that the court will take into account when deciding what proportion or how or what percentage of the matrimonial asset should be distributed.
Another question asked by one of our audiences is, how is it fair that the equity is split 50-50 even if it's the one person that's paid the mortgage?
Well, again, a court will take everything into account, and the fact that only one person has paid the mortgage and the other one hasn't, there are other factors. So, for example, one person could be paying the mortgage, but the other person is bringing the money in and pays for all the holidays, or pays for the children's private tuitions or the clothing and stuff like that.
Sorry, we'll receive a call now. Okay. জি আসসালামু আলাইকুম, কোথা থেকে বলছেন এবং আপনার প্রশ্নটি করুন। লাউড স্পিকার অফ করতে হবে ফোনের।
কি অফ করতে হবে?
আপনি যদি লাউড স্পিকারে শুনে থাকেন ফোনের লাউড স্পিকারটা অফ করতে
রাইট
হবে।
ওকে
জি প্রশ্নটি করুন।
আমি কি সাহেবের সাথে আলাপ করতে পারি?
জি অবশ্যই প্রশ্নটি করুন।
আপনি কি দেন? আমি দিলে পরে আমি
জি
প্রশ্নটা
উনি
ওনাকে করি।
শুনছেন, জি উনি আপনার কোশ্চেনটি শুনছেন।
রাইট ওকে
I recognize the voice, if I'm not mistaken.
ভাই আসসালামু আলাইকুম, আপনি ভালো আছেন?
I think it's Iqbal Bhai. Yes, I'm fine, thank you, Iqbal Bhai. You've got a very posh voice for the telephone.
তো প্রবলেম আছে আপনি জানেন।
So you got a problem?
Big problem.
Okay, so that's Iqbal Bhai.
Okay.
Iqbal Bhai is a well-known caterer. He has no matrimonial problem. The only problem he has is answering my phone calls.
থ্যাংক ইউ আমাদেরকে রিমেম্বার করার জন্য।
থ্যাংক ইউ।
Goodbye.
আসসালামু আলাইকুম।
Walaikum salam.
আসসালামু আলাইকুম।
So the next question was, if someone hasn't completed the financial process following the divorce, probably it has been 10 years since the divorce, but all of a sudden the ex-spouse needs money, can she claim?
Yes, even if a financial order has been made or a clean break order has been made and a particular spouse finds it difficult and there are assets that haven't been disclosed, you could always go back to court and make an application. And unfortunately, there has been cases of that nature where people have gone back to court to reopen orders. In fact, some people have sued their old lawyers for negligence and reopened cases after 10 years and said, well, my lawyer at the time didn't advise me properly that I was able to claim this or claim that, or my lawyer didn't do the necessary or didn't challenge the disclosure from the other side. Had they done that, and so unfortunately some lawyers are finding it difficult as well after all these years. So yes, it is a minefield, but if you discover, but going back to your particular question, if you haven't applied and you haven't settled your financial aspects of your divorce, and some people don't, you see, they have a decree absolute, they go off, they get married or don't do anything about it, then all of a sudden, they want to marry, or they've married and they want to buy a house, and then somebody tells them at a wedding or at a funeral or whatever, by the way, I had this problem, and then they decide, I need to sort it out. So, always try and tie all the loose ends if you can. You should do it, otherwise you're going to store up problems for yourself.
Well, coming from that point, there is another question asked, is that if both the husband and wife mutually agree and divide their finances but didn't place any financial order before the court, what does it mean for them?
Well, again, if both of them have made a decision and they've entered into an agreement, and as a result of which they distributed it, I'm afraid even if you make an order, even if you do an agreement and you send it to the court, the judge may not agree to it if the judge or the court feels that there is an imbalance in the agreement. Because even if the parties enter into an agreement, unlike most other disciplines of law, if you reach an agreement in a matrimonial settlement, a court could override your own agreement and say, well, I don't think this is fair. It's rare, but it happens.
Thank you. We will receive a call now.
Okay.
আসসালামু আলাইকুম, কোথা থেকে বলছেন? কোশ্চেনটি করুন।
হ্যালো, আসসালামু আলাইকুম, আমার নাম জাহেদ। আমি একটা শামবার কাছে একটা প্রশ্ন করতাম।
জি বলুন, উনি শুনছেন, বলুন।
জি শামবাই, আমার একটা মামাতো ভাই স্টুডেন্ট ভিসায় ডিসেম্বর আইছেন, বুঝছেন নি?
জি বলেন।
হ্যালো,
জি খোকা।
জি স্টুডেন্ট ভিসায় ডিসেম্বর আইছেন, কিন্তু এখন আইয়া যে ইউনিভার্সিটি হয়ে গেছে তার কভেন্ট্রি দূর ওই লন্ডন, আর ইনতাকি যাওয়া আবার ইউনিভার্সিটির খরচ তার পক্ষে সম্ভব না, মানে চালানি এমনি আইসন দিন করিয়া এখন চাইরা তাই দেশে থাকতা কাম কাজ করতা বা কোনো কিছু থাকার কোনো ইলা কোনো ব্যবস্থা করা যাইব নি?
Okay, I don't do immigration. I'm an immigration lawyer. I think there's another speaker coming in the next series who does immigration. So I would save that question until next week. So I think, but I don't do that area of law, unfortunately.
ইমিগ্রেশন লয়ার আমরা খুব শীঘ্রই ইনভাইট করছি আমাদের স্টুডিওতে। তখন
আচ্ছা।
ইনশাআল্লাহ একটু স্টে টিউন টু বিয়ন্ড টিভি ইউকে। তো
Okay.
আপনি জানতে পারবেন যে কখন আমাদের ইমিগ্রেশন লয়ার স্টুডিওতে আসবে, তখনই অবশ্যই আপনি আপনার কোশ্চেনটা আবার করতে পারেন। থ্যাংক ইউ।
ওকে, থ্যাংক ইউ ভেরি মাচ, থ্যাংক ইউ ভেরি মাচ, আসসালামু আলাইকুম।
Islam. Now, the other question is that what if there is no kind of coordination from the other part of from the other end? For example, I'll give you an example. It has been over a year now trying to sort out the finances for the divorce, and the ex is not doing anything. And what advice or information do you have for that
Well, no,
person?
because the ex has to, because what the court has a power to order them to, and with a penal notice, which means if they don't comply with the court order to file what is known as the Form E, giving details of their expense, their assets and their debts, etc., or to make financial disclosure, they could go to prison. So the matrimonial court, or the family court, as they say, has the power to send you to prison for contempt of court. So if the court makes an order backed up with a penal notice, and if the person doesn't respond, then they could go to prison. If, for example, the person has disappeared, so if, for example, the wife is left with the children and a house with a mortgage, but it's in joint names, but the husband has disappeared, or the ex-husband has disappeared, the court could make an order without him, and then what would then happen is the land registry would have to then register the property in name. The mortgage company would have to, obviously, and again it depends whether she's able to pay off the mortgage or get another loan and to pay off, because at the end of the day the court can't force the mortgage company to accept her solely as the mortgage. But there are other ways of dealing with that aspect of it, and that's just a minor aspect. But the court has the power to deal with matters if there is an absent spouse who doesn't cooperate within the family case proceedings. Or alternatively, if they've disappeared, the court has the power, and the powers are quite good actually. I know people who've gone to prison for contempt of court. Some people have gone for 18 months until they comply with the order.
In these circumstances, does the family law court looks at whether out of settlement has been done before coming to the court?
Well, you could have an out of court settlement, but the point of the matter is, like I said earlier on, the court doesn't have to accept it if it feels it's unfair for a spouse or a child or a children of the marriage. So you have to still get approval from the court. So, and again, it's for the protection of people. So, for example, you could have a spouse who is vulnerable, who's subject or prone to coercive or controlling behavior. He or she may agree to a particular settlement, but actually it's an unfair settlement. But the judge looks at it, the court looks at it and says, well, no, I'm not going to approve this because I don't think this is fair. And even when you submit a consent order to the court, you have to submit to the court your financial details about your pension, about your debts, about your assets, everything to the court, and the court will then look at your consent order, look at what assets you've got, and then determine whether or not that was a fair agreement that the parties have reached.
Okay, so আমরা প্রোগ্রামে খুব শেষের দিকে চলে এসেছি, and thank you so much for your time. Thank you so much for coming to our studio. We are really grateful.
No, it's my pleasure. Thank you for inviting me.
প্রিয় দর্শকবৃন্দ, আমরা শেষ করছি আজকে অনুষ্ঠানটি। আশা করি সবাই ভালো থাকবেন এবং সুস্থ থাকবেন, এবং নেক্সট এপিসোডে আপনারা কি দেখতে চান অবশ্যই আমাদেরকে কমেন্ট সেকশনে কমেন্ট করে জানাবেন। ধন্যবাদ।
BEONTV UK, for the community, by the community. www.beontvuk.com.
আসসালামু আলাইকুম, আমি শেবুল চৌধুরী। বিয়ন্ড টিভি ইউকেতে আইয়ার উমরাবতী নামক একটি অনুষ্ঠান লইয়া, যে অনুষ্ঠানও আমরা কথা কইমু গাছ গাছালি লইয়া, বাগান লইয়া, ফল ফুল লইয়া, এবং অতিথি হিসাবে থাকবা বিভিন্ন বাগানিরা। দেখব আপনার লাগে বিয়ন্ড টিভি ইউকে পর্দায়।
চোখ রাখুন, সঙ্গে থাকুন।